How's that? Hello, Mike Ako, and good afternoon. Mahalo for joining today's AEN-GVO deferred hearing. It's Tuesday, February 17th, and we're convened in room 225 in video conferencing, which includes the audio and video of remote participants. It's being streamed live on YouTube. In the unlikely event that this hearing is cut short, the committee will reconvene to discuss any outstanding business on Wednesday, February 18th at 3:05 p.m. during AEN's time slot, and a public notice will be posted on the legislature's website. So we have just one measure. This is decision-making on SB 2094, requiring state agencies that monitor environmental toxins and pollutants to establish environmental action levels, or EALs, to ensure the preservation of a safe environment. Prohibits modifications to EALs unless certain procedural requirements are met. Chair?
Vote, yeah.
Yeah.
What's your recommendations there?
So recommendation on this measure, would like to note that the cost to develop a government secure portal website would be approximately $125,000. Secondly, the estimate cost for creating and hosting webinars on potential EALs would be approximately $15,000. And we'd like to insert these amounts into the committee report for consideration, as well as pass with an amendment to defect the date to July 1st, 2050.
Sounds good. Appreciate you making those amendments.
Okay, any discussion? For AEN, chair votes aye. Vice Chair?
Madam Chair, we're catching up the paperwork.
We could do the
Okay,
same thing.
on Senate Bill 2094, passing with amendments, Chair votes aye, Vice Chair votes aye, Senator DeCoit is excused, Senator Rhodes excused, Senator Awa.
Aye.
Chair, you have 3 in favor, motion is adopted.
Thank you, members.
Okay, Committee on Government Operations. Let's do the vote sheet for our good Vice Chair here. Same recommendation, 2094 Senate Draft 1, I vote yes.
Chair votes aye, Vice Chair votes aye. Senator Hashimoto, excused. Senator Moriwaki, excused. Senator Awa,
Aye.
measures adopted.
Okay, thank you. You can close this out.
And that ends the 3 o'clock joint.
Okay, good afternoon. We're reconvening today, Tuesday, February 17, 2026 at 3 p.m. for decision-making on measures previously heard on February 3rd, 5th, and 10th. We are convened in conference room 225. Meeting is being streamed live on YouTube, decision-making meeting. Unlikely event, we have to abruptly end this decision-making hearing due to technical difficulties. The committee will reconvene for discuss any outstanding business at 3 p.m. Thursday, February 19, 2026 in room 225 with a public notice posted on the legislature's website. First up, we had Senate Bill 2862. I'd like to keep this going for further conversation, recognize the concerns, and so with that, we're going to amend the preamble to make it broader to cover multiple positions. We're going to make it inclusive of anyone appointed under HRS 346-381.5 to be confirmable. And then we're going to make tech amendments, non-substantive amendments for the purposes of clarity and consistency, including clarifying that the submission of GMs under Section 3A applies to gubernatorial appointees who were not subject to the Senate's advice and consent and are still serving in the appointed position. And because of these changes, we're going to also add an effective date of 25/25. That's all we have. Members that are present, questions or comments? If not, recommendation on 2062 is a Senate Draft 1, with noting the excuse of my Vice Chair. Are there any other WRs or no's? Okay, seeing none, this recommendation was adopted. Give me a second, I'm having to multitask a little here. Okay. Next up, 2781, relating to lay. We want to keep this one going too. We heard all the concerns that were raised, and so given that, we're going to do a Senate Draft 1, and we're going to create a working group to identify, gather, and report on any existing studies or assessments or data by DAB or University of Hawaii that have already examined the following. number, distribution of flower farms in Hawaii, type and volume of lay materials currently produced locally, and the capacity of local floriculture to meet the expected public demand, as well as their ongoing private demand. Require the working group to conduct a statewide study of Hawaii's floriculture industry, looking at production capacity and barriers faced by local growers. And the working group will be comprised of the chair of DAB, the president of the Farm Bureau or the representative, president of the Hawaii Floricultural and Nursery Association or their representative, the CTAR dean or their representative, one member from the florist industry named by the Speaker of the House, and one member of the lay maker producer industry named by the Senate President. Oh, we're also going to add technical non-substantive amendments for clarity and consistency. Effective date of 25/25. Members, are there any other questions or comments? If not, recommendation is a Senate Draft 1. I vote yes, noting the excuse of my Vice Chair and Senator Hashimoto, Senator Moriwaki, Senator Wa. And that concludes that one. Okay. Okay, next up, 3015. We're going to keep this one moving as well. What we're going to do to address the concerns and make it universal for everybody is we're going to adopt California's definition of PII, which is been sorely needed in the state among all these different branches. We're going to make it applicable to government agency branches and political subdivisions to remove and disallow PII under the new definition. Create a private cause of action if PII is identified and not removed. Report to the legislature on compliance of the act. We're going to address the preamble to address current technology and issues with government entities as trusted sources in relation to PII. We're going to also make several technical non-substantive amendments for clarity and consistency. And because of the changes, we're going to add an effective date of 25/25. Members, questions, comments? If not, 3015, Senate Draft 1, no the excuse of my Vice Chair, Senator Gabbard. Are there any WRs or no? No for Senator Wa. Okay, anybody else? Seeing none, that one has been adopted. Okay. Relating to procurement, the next one up is 3230. And this bill here, what we're going to do is we're going to remove the categorical statutory prohibition for procurements of services for project management through non-governmental third-party contracts and add language that oversight of third-party contracts remain state agencies' inherently governmental responsibility, reference to procurement circular number 2014-14. This is the amendments that were requested by the State Procurement Office in moving this bill forward, and an effective date of 25/25. Members, questions, comments? If not, recommendation is a Senate Draft 1, noting the excuse of Vice Chair Gabbard. Are there any WRs or no's? Seeing none, that recommendation has been adopted, and I believe that takes us to the end of this decision-making agenda. We'll take a short recess before beginning our joint GVO Health and Human Service agenda. All right, welcome back. Now convening the Joint Committee of GVO Health and Human Services, 3:05 p.m. agenda. Convene conference room 225. Two bills on the agenda. First up, 2932, relating to state facilities. Requires all state building construction beginning on or after 7/1/2026 to provide at least one universal changing accommodation in each public restroom. First up, we have DAGS.
Chair, we stand on our written comments as
Thank you so much. We appreciate those comments. Disability and Communication Access Board.
I will stand on our testimony.
Thank you. Appreciate that. We have Hawaii State Council on Developmental Disabilities.
Chairs, committee members, Dane Bartolos, Executive Director for the Hawaii State Council on Developmental Disabilities. We stand in strong support. I first want to begin by thanking you so much for hearing this measure. This measure came from our Maui Disability Forum. They are very excited about getting this heard. We want to start somewhere, in the state buildings is what they requested. I apologize for my testimony to ask to include counties. We can't. It's a state building, and I apologize for messing that up. And we also are in agreement with DCAB's request for changing. There's a little blurb down there at the bottom that we are in agreement with. Thank you so much.
You're making an amendment? Okay, sounds good. I thought that was in there already. feasible is already in the bill. Okay, well, let's
No, they
continue.
want the phrase technically infeasible.
Oh, got it. Okay, got it. I see what you're saying. Okay. Anyway, sorry, we took a little side trip there. Next up is Civil Rights Commission. Oh, you already went. Next up is individuals, a lot of them. Annette Tashiro, Jari Sugana, Desiree Taku, Veronica Moore, Leilani Kaliavao. They are all in support. We have Goodwill Hawai'i. They have written in support. We also have Austin Kanashiro and Iris Zhao, both individuals in support of the measure. That is all we have on that measure. Is there anybody in the audience wishing to testify? Yeah, come on.
I'm pretty sure that I sent it on behalf of the Disability Rights Center for both bills.
Oh, I apologize. Yes, you were right there.
Okay.
Familiarity
No problem.
brings exception.
Well, I don't think I need to make a long speech on these bills. You folks are very familiar with the issue, particularly the chairs, and I think the committee is. So my testimony goes for both bills. We're in support. I think that what Daintree is suggesting and what DCAB is suggesting, I think kind of cleans up the language. There might be some question about, I see DAGS wants to make it design versus construction, and that's a call for you folks. But basically, conceptually, this is a really good idea. We've been advocating on this for several years, and I think both of you have been supportive before, so we appreciate that.
Great, thank you so much. Anybody else? Seeing none, questions of the testifiers?
I have a question.
Yes.
Get off. Just real quickly, you mentioned that you're responsible just for DAG's managed buildings. Do you think you can make the language clearer that it really does apply only to a state, well, I guess DAG's owns or managed buildings or something like that?
Yep.
So that's clear in the law that that's what you're going to be responsible for? Can you give us language that we could put in that would specify that it's just what you're responsible for?
Yeah, so thank you very much for that question. Just so you know, I want to just start by saying that we support the intent of this bill. We think this is a good direction for the state to move in. And so we're not in any way opposing what's presented here. We just are asking that while DAGS does manage a number of buildings, it doesn't manage all buildings. And so we want to make sure that if there's signage that's required as part of this process, that those buildings that are non-DAGS managed are required to put up their own signage. And so we did, in fact, include some language in our testimony, but we would be happy to clean it up if you need us to make it a little more.
I think so, because do you know how many other buildings are managed by other than DAGs?
So there's like something like 8,000 buildings throughout the state,
But-
right?
but are
So
they
we've
state-
got about 120 that are managed by DAGs.
Yeah. So I think 120 is kind of more manageable than 8,000.
It is, and like I said, we have no problem with doing this in our facilities, but there's no way that we can mandate or, do all 8,000, the other 7,000 something buildings, right, that are out there.
So maybe you can give us some language. Chair, I think if we can confine it to what the state manages.
That's kind of what the intent
Yeah,
is. And we're
yeah.
actually going to adopt the amendment, your amendment, as well as the amendments of.
So does it state?
It does.
Yeah, you, Daintree, you didn't have any, did you?
No, she did.
Yeah, we're just going to take these two guys
Yeah.
and make their amendments.
They
Because she
choose
had
to
the-
add the county.
She does have.
No, she can't add the counties.
No, but she has the, it's one per building and not one on every floor, something like that.
That's the next bill.
Oh, that's the next, oh,
Yeah,
sorry.
that's the next bill.
Okay.
Yeah.
Okay.
So those are
As
the
long as it's
recommendations. We're
language.
going to go with these two guys' amendments and their effective date, okay?
Thank
you.
Okay.
Okay, make sure we remember that. All right, anything else on this bill? Seeing none, we're going to move on to the final one, 2268, very similar, but they are different. I want to let you guys know that, so just so everybody's aware. Let's see, first up, DAGS.
Chair, we stand on our testimony providing comments on this matter.
Okay, thank you so much. We also have the AG's office.
Good afternoon, chairs, and any member of the committee. My name is Charles Lee, Deputy Attorney General. We submitted our written comments to IRA on some implementation issues, so I'll be available for any questions.
Okay, sounds good. Let's see, we have DCAB.
We'll stand on our support and say we support the council's.
Okay, sounds good. Next up, we have the LGBTQ plus commission. They have Zoom. Are they here?
Not present, Chair.
Not present. They have submitted testimony in support. We also have State Council Developmental Disabilities.
Thank you, chairs, committee members. Daintree Bartolus, Executive Director for the Hawaii State Council on Developmental Disabilities. Within our testimony, we did highlight and request a couple of amendments that we felt would be a little bit more feasible to support the implementation. Although we really appreciate it to be on every floor, but we felt like at least as a changing table, at least one in the building, that would be a little bit more feasible to implement. So on the back of our testimony on page 2, we said on page 2, line 15, delete on each floor containing restrooms for public use. Line 16, delete each new establishment shall provide at a minimum and replace it with each new establishment shall provide at a minimum at least one universal changing accommodation within the building in a restroom for public use as follows. On page 3, lines 18 through 19, delete. No reasonable physical option exists for providing universal changing accommodations, and replace it with is technically infeasible as defined under the ADA. Thank you for this opportunity to provide testimony and support.
Okay, thank you so much. Next up, Hawaii Civil Rights Commission in support. Hawaii Disability Rights Center. Support. Okay, sounds good. Pride at Work Hawaii via Zoom.
Not present, Chair.
Not present. I see Hawaii Civil Rights Commission on the.
Good afternoon, chairs and committee members. Constance Jonashiro for the Hawaii Civil Rights Commission. We are in strong support and stand on our written testimony. While this measure will create a new section in Chapter 489 is outside of the HCRC jurisdiction, we believe that by ensuring access to safe, universal changing accommodations in public spaces, individuals who need help with self-care can more freely partake in social interaction, connection, and a sense of belonging in our communities. Mahalo for the opportunity to testify and support.
Okay, thank you. Sorry about missing you there. Let's see. We have Pride at Work Hawaii. Okay, we have Hoku Pack. By the way, they're in support, just so everybody knows. Hawaii Women Lawyers. They are in support. We have Alec Martinek, individual in support. Annette Tashiro, individual support, and our friend Judith Clark on Zoom. We see you, Judith. Go ahead.
Aloha, chairs, members of the committees. I am Judith Clark, a community advocate and the former chair of the Hawaii Children and Youth Summit, and I support this bill. In 2017, 2 women brought their babies to the Hawaii Children and Youth Summit at the State Capitol building. A young parent who was a speaker at the summit came to me and asked where she could change her baby because there was no baby changing station in any of the women's restrooms. The adult volunteer provided us with a photo of herself kneeling on the floor of the bathroom in the Capitol to change her baby. And I've included a copy of that photo in my testimony. Sharing this photo and information with legislators led to the installation of changing tables in men's and women's restrooms at the Capitol. Parents and children need and deserve appropriate and accessible facilities in public buildings. They should not have to kneel on the floor to provide essential infant care, and recognize that some parents and caregivers have disabilities that make this impossible. Thank you for this opportunity to testify.
Thank you so much, Judith. We appreciate you coming on Zoom and testifying. We also have Jerry Sugano, who they indicated they would be here. Okay, written in support. Also Uday Finch, Desiree Takub, Katerina Advienko, and we also, Veronica Moore and Leilani Kailavau. They are all in support. We also have Riley Detman for Goodwill Hawaii in support, and Austin Kanashiro, individual, in support. That's all we have on the measure. Is there anybody else wishing to testify? Seeing none, members, are there any questions?
Oh, I do. Just of Daintree, real quick. You mentioned the definition of technically feasible, infeasible under ADA. Can you give us the actual chapter and verse of ADA so that we can make sure we have the right?
Can I ask Brian from DCAB to help me with that? Because I got that language from him.
So ADA is pretty broad. So, any
Yes,
specific?
hi, Brian Vick here on behalf of the Disability and Communication Access Board. I thought you had the exact citation,
Yeah.
but the language, and in our testimony on 2932, we included it. Technically infeasible means something that has little likelihood of being accomplished because existing structural conditions would require removing or altering a load-bearing member that is an essential part of the structural frame, or because other existing physical or site constraints prohibit modification or addition of elements, spaces, or features that are in full and strict compliance with the minimum requirements. So it's a fairly narrow definition that we think would avoid people trying to stretch some of the other terms that are in the bills and leading to disagreement.
Do you have that in your testimony?
Yes, that's in our testimony, yeah,
The prior bill.
On the prior bill.
on the prior bill.
Not
yeah.
on this one.
Yeah, I think,
Yeah, the prior
yeah,
one is about state facilities only.
Yeah.
We're gonna definitely do that on the prior one, but on this one here, I think this is more getting into, because this is in a different section of the HRS, right?
yeah, and I think in DD Council's one, it said technically infeasible as defined under the ADA, so.
Yeah, see, there's a difference.
Yeah. Yeah,
So there is a definition section under the ADA accessibility guidelines. And that's my understanding is where the technically infeasible phrase is defined.
As long as we have some citation, what that is.
But that's in your testimony, right?
That's
in the
not on
first
this
one.
On the first bill, yeah.
Yeah.
On this one,
Is it the same one?
Same one, right?
It's-
Okay.
yeah.
And we just got two, he's speaking on the first bill for it, she's speaking on the second bill.
Yeah, but I mean, is the definition the same?
Yeah, as
Yes.
defined under the ADA, it is the same
So the bullet
definition.
pointing, the difference would be the way the second one is, if they were to adjust the ADA's definition, they would automatically be referring to the ADA. If you put it directly into the statute and they change and you want to match it, then you have to go back into the statute
If you
to update it.
pull up ADA,
Yeah.
there is a definition table, and in the definition
It has
table,
technically infeasible.
it has the phrase technically infeasible.
We'll define it under definitions with that. Okay, so like you said, if it changes,
Just to be sure.
and we don't have to go
we
back
know
and
what we're
change the
talking
law.
about.
Correct.
Word for word.
Word for word.
Okay, sounds good.
Sounds good.
Thank you.
Thank you.
Chair, so I'm not sure if this question can be to you guys, but I see that this is going to be beyond government buildings.
That was the first one.
Oh, that's the first one. We still have the second one.
Second,
Go to the second one now.
2268, right?
226.
Right,
No, this is what
2268.
dragged us back.
Oh,
was
sorry.
technically infeasible, but yeah, this is the
Sorry.
second one.
Yeah.
The first one's only for state facilities. We are going to make it prospective with Dags's amendment and also put in the technically infeasible in respect to that from CAP. But this is technically infeasible being applied to discrimination, right, chapter. That's why they're two different bills, despite the fact, I thought too at first glance. Oh,
Okay,
it's the same.
looking at the 2268 says beyond government buildings and private sectors.
Yes, that's the reason why it's different. This goes beyond government buildings.
Yes, and 2268 allows for right of action. Okay, which
Private
the
cause of
Attorney
action, which is in the
General-
other one passed too.
Yeah, which the Attorney General wants.
I just figure sometimes small business is not going to be able to do some of this.
No, there are concerns, I mean, with the second one for sure, insofar as the impact of the private sector goes, but, you know, that's, we're just looking at it from the government side.
Okay. But we're not going to have public bathrooms at the restaurants because they don't can afford them. They're going to end up closing it to public.
Well, I think that's where the technically feasible comes into play, right there, right?
And that's the reason why Daintree suggested instead of to only limit it to one per building,
Yeah, one per building now, too.
so that it won't be, instead of one per floor.
Thank
Try
you.
to make it as accommodating as possible.
Okay, thank
Good?
you. Yep.
Anybody else? You guys good? You? No? Okay.
Thank you again.
Do you want to just roll into GM, and we'll just take our vote now for...
Yeah, and I have a quorum.
Oh, you do? Okay, so we both can do it. All right. Well, then we'll just go right into it then. 2932, we want to keep this conversation going. It is a different bill. This is state facilities. We want to put the prospectiveness and other amendments offered by DAGs into the measure. Also, we want the amendments, including the technically infeasible from DCAB in there and an effective date of 25/25. Members, questions or comments on this measure? If not, it's a Senate Draft 1, noting the excuse.
I'm voting your vote.
Oh, you are, thanks. You're the man, okay.
SB 2932, recommendation is passed with amendment. Chair votes aye, Vice Chair's excuse. I vote aye. Senator Marwaki.
Aye.
Senator Awa.
Aye.
Chair recommendation is adopted.
For HHS, same recommendation. Vice Chair for the vote.
This is really confusing. Okay. Noting the presence of all the members except for Senator Kale Kaloli, is there any WRs or no? Seeing none, recommend. Oh, and Kanuha too, I'm sorry. Any WRs or no? Seeing none, recommendations adopted, Madam Chair.
Okay, thank you.
Okay, this is very strange. 2268. I believe what we're going to do on this one is we're going to take the recommended amendments of Dingtree offered for the bill, which is limiting it to the one per building, correct? And then the technically infeasible again, right?
And AG's proposed amendment.
Oh, and the AG's proposed amendments for implementation, right?
Yep.
Okay, so we good?
Yep.
Okay, and an effective date of 25/25.
Technical amendments.
And technical amendments for that clarity and style. Any questions or comments? If not, thank you, Vice Chair Pro Tem. I vote yes.
SB 2268, Chair's recommendation to pass with amendments. Any members voting with reservations? Any members voting no with the excusal of Senator Gabbard? Your recommendation is adopted.
Thank you so much.
And same recommendation, Vice Chair for the vote for HHS.
Okay, noting the excuse of the members previously mentioned, are there any WRs or no's? Seeing none, recommendation is adopted.
Thank you very much.
So this concludes this hearing. Welcome back. Now convening the Joint Committee for Government Operations, Public Safety, and Military Affairs for our 3:30 p.m. agenda. We are convened in conference room 225. On this agenda, we are the lead on the first two items. We have Senate Bill 2882 relating to state buildings, requires certain state buildings intended for use as emergency shelters constructed on or after July 1st, 2027 be designed to withstand a Cat 5 hurricane. First up, Dags.
Chair, we stand on our written testimony providing comments.
Okay, thank you so much. James Barros, Haima. Written in support. We have Department of Education. They have submitted comments. They're here on, no. We also have Dr. Keone Dudley on Zoom.
Not present on Zoom, Chair.
Okay, and then several individuals, Sherry Pollack, Veronica Moore, Michael Plowman, and late from James Gower, all in support. That's all the testimony we received. Anybody in the audience wishing to testify? Seeing none, are there questions of the members? I don't have any questions. You? No? Okay, we'll move on to the next one for which we're lead. It is Senate Bill 3191 relating to Department of Water Safety and Drowning Prevention, establishes Department of Water Safety and Drowning Prevention, and establishes the director of said department. First up, we have Allison Schaefer's individual.
Not present on Zoom, Chair.
Not present on Zoom. Okay, and then late from Ron Bregman. And they're both in support. That's all we received on 3191. Anybody in the audience wishing to testify? Seeing that nobody's here, there's nobody to ask questions of, so I'll go turn it over on the final bill to my co-chair.
Wow, that was pretty speedy.
We move quick.
Next, we have Senate Bill 2339. This was, let's see. First up, we have Stephanie Sakamoto for Building Industry Association. Okay. Next, we have Richmond Luzar in person, testifying for Housing Hawaii's Future. If not, next we have IBEW Local Union 1186, Michael Pacheco Pika Bukowski, Plumbers and Fitters, UA, Local 675. And let's see, last, Gina Thielen in person, welcome. Yes, please.
Aloha chairs, members of the committee. My name is Gina Thielen. I'm here to testify in support of Senate Bill 2339. I currently work as a developer in the affordable housing sphere, primarily Bill 7, the City and County of Honolulu's program. I've been a licensed general contractor for 30 years, and in my volunteer capacity, I serve as the chair of BIA's Codes Committee. I serve on the City and County of Honolulu Building Board of Appeals, and I am the vice president of the Hawaii State Habitat Association. I'm a strong believer in affordable housing, as you can tell from this background, and building codes have become a very big priority for us. I believe this bill is very important because we have been rotating seats between two agencies that really look at different areas of the code. BIA Hawaii's members are primarily focused on the IRC, or International Residential Code, which affects most of the single-family homeowners. And the GCA is focused more on industrial construction, like IBC. So I think giving both organizations a seat is going to help bring a good perspective to the State Building Code Council. Thank you.
Okay, thank you very much. That's all the testifiers that we have on our listing. Is there anyone else who would like to testify on Senate Bill 2339? Okay, if not, we'll briefly recess and
Yep, we'll just recess briefly.
proceed for discussion.
Welcome back, everybody. Okay, I just had to take a brief recess here, but given that, we're back for decision-making. And so after talking to my illustrious co-chair about this measure and reviewing the testimony on the first measure, 2887, the recommendation is that we're going to take the amendments offered by both DAGS and DOE and put an effective date of 25/25 on there to discuss the changes that we're making to the bill further. Members, any comments, questions? If not, recommendation is Senate Draft 1, no excuse. No, 2882 is the bill we're voting on. And the recommendation is that we pass with a Senate Draft 1 and noting the excuse of my vice chair, other than any WRs or no's. Seeing none, it has been adopted. Go ahead.
Okay, for PSM committee, same recommendation?
Quorum, Senator. No quorum.
Oh, okay. We will defer decision-making
Okay.
until our program slot.
Sounds good, sounds good. Next, we have 3191. Recommendation on this to keep it going for further conversation is a Senate Draft 1. And we're going to go ahead and make technical non-substantive amendments for the purpose of clarity and consistency and an effective date of 25/25. Questions, comments? Any funding will be noted in the committee report and blanked out. Just make sure we're clear. Questions, comments? If not, noting the excuse of my vice chairs, any WRs or no's? Seeing none, recommendation has been adopted on this end.
Same recommendation for PSM committee, and we will we will do our decision-making during the time slot we have downstairs.
Okay, next one, the final one was you.
Oh, that's right. Senate Bill 2339, relating to the State Building Code Council. Chairs would like to recommend that we pass this bill with amendments and add 2 labor representatives to the Building Council, in addition to separating the contractor representatives as requested in the bill, and include a defective effective date just to continue the discussions. We think that this will provide some additional balance, and we look forward to seeing this bill move forward. Members, any questions? If not, we will defer till our time slot.
Okay, sounds good. Members of GVO, same recommendation, Senate Draft 1. Are there any Questions, comments? If not, noting the excused absence of my vice chairs, any WRs or noes? Seeing none, this recommendation has been adopted. And I believe.
Okay, I have one correction to my announcement. The deferral that we're making on the PSM items is till tomorrow afternoon at 3 p.m. in conference room 016.
All right, welcome back. 3:45 p.m. agenda, government operations, 225, Thursday, February 19th, 2026. First up, only bill 3294 relating to wrongful imprisonment. We have first up the Judiciary State of Hawaii. They have comments, AG's office.
Good afternoon. My name is Michelle Pulu. I'm a Deputy Attorney General with the Criminal Justice Division with the department. We are the department's statewide prosecutors. We oppose this bill for various reasons. One being the automatic payment system that is being set up by it. Basically, there's going to be an automatic payment system that is set up before any legal determination has been made that establishes actual innocence. That means there has been no finding made that the person is actually innocent. To the 5 days that's being permitted to allow the prosecutors to refile or re-pursue the trial is wholly insufficient to make a thoughtful determination to whether or not the case is viable for re-prosecution based on what is left of the case. Sometimes these Rule 40 petitions are granted sometimes 20, 30 years post-conviction. In the Alvin Jardine case, that was, I want to say 30 years after the fact. It's very difficult to put together a trial 30 years after it's done. Time is going to be needed to determine whether or not that's even possible, whether or not the victim wants to proceed. 5 days is wholly insufficient. Meanwhile, those automatic payments are going to be doled out at taxpayer expense. 3, there's going to be no opportunity to recoup those monies if the 661B petition is subsequently denied because there is no finding of actual innocence on the part of this individual. That means these payments are going to be going out based on defects in the trial that is found by a court reviewing what happened at the trial, whether or not jury instructions were proper, whether or not improper arguments were made during the trial, whether or not evidence might have been withheld, whether or not new evidence was brought to light based on new technology that is now available this year that wasn't available in 1990. This would warrant automatic payments under this system. Also, there's a potential constitutional violation where there is no appropriation for these funds having been made. We do oppose this bill. We'd ask that it be deferred.
Okay, thank you very much. Okay. Let's see, next up, we have Office of the Public Defender.
Good afternoon, Chair and members of the committee. My name is Haley Chang. I'm the first deputy from the Office of the Public Defender. We have submitted testimony in strong support of this measure and want to clarify a few things. This measure will apply to an incredibly small group of individuals. This is very distinctual from somebody who has been detained pre-trial, has gone to trial, and has been found not guilty. That is not who this applies to. It applies to people who have, as the measure states, been wrongfully imprisoned. And wrongfully imprisoned with a finding that the evidence supports innocence. So we do disagree with what the Deputy Attorney General's testimony is that there is no findings. As the bill clearly states, the vacation of the conviction or reversal has to be supported and has to be done with this evidence supporting innocence. One of the most inhumane and tragic things that can happen in our criminal system is that someone be wrongfully convicted and then wrongfully incarcerated for 5, 10, 20 plus years. Often these individuals, unless they have a strong support system, come out with nothing. And that can often be worse than incarceration itself. With incarceration, at a minimum, you have shelter, you have meals, you have maybe minimal medical assistance. But if you are released from custody after perhaps decades and you have no resources, no funds, not even the basic necessities, it can be worse than incarceration itself. When these few individuals in our system are wrongfully convicted and there is evidence later supporting innocence, we believe very strongly that this is the minimum that the state can do to try to rectify the wrong that has been done to these individuals. So we stand in strong support. Thank you for the opportunity to testify, and I will be available for any questions.
Okay, thank you so much. Next up, we have Keith Regan,
Chair, we stand on
Comptroller.
our written testimony providing comments on this measure.
Okay, thank you so much. We have Gilkeith Agaron, Takatani Agaron, Jorgensen, and Wildman. They have written testimony in support. We have the law offices of Setsuko Regina Gormley. They have written testimony in support. We have numerous individuals, Lynn Akusaka, sorry if I butcher your name, Virginia Tincher, John Kawamoto, Douglas Hagan, Thomas Graham, Paul Bernstein, Virginia Hench, Noel Morum, Don Dural, Ron Riley, Gordon Cordero. They are all in support. Late from Sarah Cordero. That is in support. Gordon or Sarah? Gordon was supposed to be on Zoom. Are they on Zoom?
They are present, Chair.
Okay, go ahead, sir. Go ahead, Gordon. You got your timers running.
You want Gordon? Okay. Senator McKelvey, Chairman, Senator Gabbard, Vice Chair, and members of the committee, thank you for inviting me to testify today. I truly wish I could be there in person, but I was not feeling well this weekend. I'm glad you gave me the opportunity to speak. My name is Gordon Cordero. I was released from prison February 21st, 2025. I filed a reporting petition. A hearing was held. Evidence was presented. Prosecutor had the opportunity to respond and oppose the petition. Witnesses testified.
Oh, we just lost your audio, sir. Gordon? We lost your audio. We can't hear your testimony.
Can't hear you either, looks like.
I can't hear me either. I think the system has gone down. IT, can you hear me?
Yes, sir, we can hear you.
After my release.
Are you there, Gordon?
Hello?
Yeah, okay. Go ahead and
Can you hear
pick
me?
it up. We lost a good chunk of it, so why don't you just go ahead and recap real quickly?
Okay, if I was walked to the gate, the door was open, and it was shut behind me. If I had not had my families and friends and attorneys waiting for me, what would I have done? Where would I have gone? What would I have eaten? Where would I have slept? I didn't even receive the small amount of money I earned while working in prison until 3 months after I was released. This bill is essential for anyone being released for actual innocence. When someone is released on parole, they have a case manager, they have a supervision, they have people helping them get settled in the community. When someone is released because of actual innocence, they have nothing. No plan, no assistance, no safety net. When I went to prison in '94, we were carrying beepers. When I left, there were smartphones and smart TVs. Everything changed. I spent 3 decades in prison. Last week at the House hearing, I heard the Attorney General's comments opposing the $5,000 advance payment. I disagree. It costs the state between $60,000 and $115,000 a year to house someone. They will never get that money back for somebody who is actually innocent and put in prison. The $5,000 is not a bonus. It's a bridge to help you get on your feet, to help you get moving. The original bill, 661, was a good bill. However, over time, it's been undermined by the Department of the Attorney General. They argue, they negotiate, they try to give you less money than you deserve. Alvin Jardine died waiting to be paid when he got out of prison. A judge has already ruled someone actually innocent. That should not trigger a negotiation. The burden should not be on the person to prove they deserve compensation. The determination has already been made in court.
Okay, so the timers run out. So your timers run out, so I'm going to need you to summarize so we can move on to the next testifier.
I definitely support this bill, and I hope you guys vote yes. Justice is not opening the gate and walking away. Justice is making it right. Thank you for your time.
Okay, thank you, sir. Appreciate you testifying. Gina, we see you. Go ahead. Your timer starts now.
Good afternoon.
Go
My
ahead,
name is
Gina.
Gina,
Yep.
and I am a solo practitioner on Maui. I also am a volunteer attorney with the Hawaii Innocence Project. I do support this bill for a number of reasons. One of the reasons is that it proposes replacing actual innocence with grounds consistent with innocence. I think that's extremely important. As the Hawaii Supreme Court recognized in the Jardine case, the standard is nearly impossible to satisfy. Another reason is for the advanced compensation. Currently, probationers have services, parolees have services, and yet the wrongfully convicted have zero services. As Gordon stated, they come out with nothing. Hawaii Innocence Project had to help Gordon. His family also helped him, but we also had to help him along with Ian Schweitzer. We had to help Ian Schweitzer obtain a bank account or open a bank account and also get an ID. In Gordon's case, he had to use MCCC's address on his ID because he could not establish residency. So we do need services, advance payment, compensation for the wrongfully convicted, because again, they are released with nothing. Once they walk out that door, they have nothing, no housing, no ID, no employment. They don't have Social Security. They don't have a job. In some cases, they don't have clothes. They have nothing. And so another important reason is that it shifts the burden to the state. The bill streamlines the procedure and shifting of the burden of proof to the state to show why a person shouldn't be compensated if their conviction was vacated on grounds consistent with innocence. What we have to remember is that these are our people. These people, we have to take care of them. The state did them wrong. They spent, in Gordon's case, he did over 30 years. Alvin Jardine did over 20 years. Ian Schweitzer did over 23 years. Ronis Doral did over 8.5 years. But these are everyday people that this can happen to anybody. It can happen to our family members. It can happen to our friends. And we have to remember that. And we need to take care of our people so they're not just left destitute or, in Alvin Jardine's case, left for dead. Thank you.
Okay, thank you very much. Let's see, that's all we have on the measure. Is there anybody in the audience wishing to testify? Sir?
Yes, sir. My name is Ronis Doral. I was also wrongfully convicted. When we get out of prison, we come out traumatized. People who committed crimes, they get out, they should be rehabilitated. We're not, we're traumatized. People who get out after they committed a crime, they get out and they hope the public, they try to work to gain the public's trust. We have to work to trust the public again. So it's a whole different set of circumstances for us. And the advanced compensation, it stops the AG from using the tactic that they use. For myself, if I would have qualified, I qualified for the $500,000, but they told me, well, we'll just appeal it and send you to court. And so if I would have went to court, it would have took me another 2-3 years to get the money, and then I would have lost more money because I would have had to pay an attorney to fight them in court. So they know if we don't have the advanced compensation, they get to just play the long game and just drag us out until we end up like Jardine and dead if we don't have family members to help take care of us. We quickly go from blessed to be out to scared and trying to figure out how do we survive once we get out. And then you ask, who does this happen to? Before this, I was a military member. I was in the Navy. September 11th happened. I'm manning my battle station, ready to defend this island in this country with my life. I felt a sense of pride. I deployed for 7 months after September 11th. I was awarded a medal for saving a life. I did all that stuff, and I came right back here to be wrongfully convicted and sent to prison. And then, everything I fought for this country, I didn't even get to enjoy the benefits of the Constitution that I supported and defended. So this bill helps us to say, you know what, we got it wrong. Let's help us make us right. We're not, our system is not a perfect system, but it's supposed to be a fair system. I'm not entitled to a perfect trial, just a fair trial. And when the state gets it wrong, they should stand up like they want other criminals to do, stand up and say we're sorry, and they should take accountability for it. To date, they have not said a sorry to not one of us. It don't care if it's DNA, non-DNA, it doesn't matter. All our cases have been overturned, and not one time have they stood up and said, we got this wrong and we're sorry, and I think that's a shame.
Okay. Thank you for being here and testifying, sir. I appreciate you sharing your story. Let's see, that is all we have on the measure. Is there anybody else wishing to testify?
Mr. Chair, I think Sarah would like to testify.
Okay, Sarah, go ahead. You have 2 minutes starting now. Go ahead, Sarah.
Sorry, it's technical difficulties. Hi, aloha.
Aloha.
My name is Cordero. My brother is Gordon Cordero. Gordon was released a year ago this coming Saturday. It has been a year of reconnection, attempted healing, making up for lost time, and struggling to reacclimate. I shudder to think what it would have been like without our support. I could speak to you for hours about what he and our family experienced during his 3 decades of wrongful incarceration and the injustice he had already endured, but that's not what this hearing is about. This hearing is about the injustice that follows release. It's about what happens next. He was left at the gate with a paper bag. He was released without the resources or structured support he needed to begin again. Today, Gordon is trying to rebuild his life in a world that has completely changed. He faces enormous challenges emotionally, physically, medically, and financially. And we are here for him every step of the way. But what if we weren't? If not for our continued support in every way, including financial, where would he be today? Homeless? Alone? His daily living and medical needs unmet? Or worse? This bill is important because it recognizes that when someone loses decades of their life to wrongful imprisonment, they need immediate support. They need stability, medical care, and guidance. They need dignity. They should not have to struggle alone after already enduring such a profound loss of time. Nothing can give Gordon or our family back the 31 years he lost. But this bill can help give him and others like him a real chance to rebuild their lives. It represents accountability. It represents compassion. And it represents a true commitment to justice. Please
Okay,
do not let
Sarah, the timer has ended, so I'm going to have you wrap it up here so we can have the other testifiers jump on.
Of course. Please do not let another innocent person walk out of prison with nothing but the clothes on their back and no place to begin again. I respectfully urge you to pass this bill. Thank you.
Okay, thank you very much. I also got a note that there is a Gina Gormley who would like to testify. Is she on? She did already. Yeah, that's what I thought. She already did. Okay, sorry about that inadvertent mistake. That's all we have on testimony. Anybody else wishing to testify? Seeing none, members, are there questions at all?
For the Attorney General.
Okay, Attorney General, this question for you. Come on up. Testimony is closed. We're going to have questions now.
Yes, Senator.
No.
Yes, you've heard all the concerns about why the delays in
I did.
these cases. Can there be anything done on the prosecution side or whatever in terms of the process? And can you fix the process so that it isn't 20 years of false incarceration?
Thank you, Senator. So part of the issue was when this statute, the 661B, was enacted in 2016, it had the language actual innocence, and there was some difficulty interpreting what that meant. So we were interpreting it very literally as to what that meant. There was no decision ever issued that said actual innocence was the finding by the appellate court in any Rule 40 petition. So taking that literally, having been no finding, that's what they were being held to. There was a recent decision in the Jardine case where the standard was lessened to this grounds consistent with innocence. Since then, in 2024, they've been afforded some direction into what that meant, and that helped stimulate the conversation better in terms of settlement and gearing it towards settlement. Since then, there have been settlements that have been entered into. And the settlements work in a manner to where, because there are facts still on the prosecution side of the case that are not consistent with innocence, and there might be some factors that might be consistent with innocence, that's how settlements happen, right? But that's a process that needs to happen through the legal channels, not through an automated system.
So is there anything that needs to be amended in terms of how that could be expedited? Is it a petition? But because, sometimes the prisoner doesn't know that they have these rights, and how can it be brought to the attention so that it is assessed?
I don't know that anyone's not aware that they have these rights to pursue a petition under 661B. I honestly can't answer that, whether or not they're aware or not aware. It's certainly becoming more aware. The issue of whether or not there needs to be a change in 661B to address that, our department doesn't think so. We do think these cases are moving forward. I don't know.
The other issue that seems to be here is what the comptroller has said is, who's going to pay, how much is it? It's an undefined number. At what point is it defined? If it is at $5,000 a month for as long as you've been incarcerated, or what is something that's limited, because we don't have an unlimited budget.
Right.
So what might that be, so that it is either capped, or there's something that's there that we have amount specific?
My understanding, Senator, in reading the language of the bill and also 661B, is the cap is $50,000 per year that you are incarcerated. I believe under this bill, it would be the same. So although you're under the bill entitled to the $5,000 per month, that would not exceed the $50,000. And it's per year that you're incarcerated, albeit wrongfully is the standard, that you were wrongfully incarcerated.
And the last question I have is, who administers this? Because the courts say, no, it's not us. Would it be the Attorney General's office? I know the payment comes from DAGS, but who's to make that decision to say, okay, DAGS, pay?
Well, my understanding, per the way the bill is written, it's supposed to come from the comptroller. I'm not sure who would inform the comptroller that the $5,000
that's my question. Who
payment needed to be
informs?
made.
Yeah.
Who informs the comptroller to pay?
It doesn't
X?
say.
Yeah, I guess, I don't know. What would you say?
I'm not to have my own personal opinion. I don't know.
While we're up here, we got written testimony from Karen Oshiro, who came late, so I apologize about that. But in there, they suggested, I thought it was an interesting idea, that upon release from incarceration, that they should be provided the same resources as those who've released for time served or parole. Would that be a way to give people resources that they need, that it would be applicable to them as well as to other prisoners being released?
I believe purposefully we did not comment on those portions of the bill, which basically state to give these individuals a caseworker, so that they would have somebody to help assist them with that transition process upon release from incarceration. There are some individuals who are actually already out on parole when their convictions were overturned. So I don't know that they would be in need of that type of assistance. I guess it would be case dependent, but if they were being released from custody, perhaps they could be afforded that, but that would also be a jurisdictional issue, because corrections has testified that they can't be the person to do that because they no longer have jurisdiction over someone who is not in their care and custody or control. There was adjustment to the House version of this companion bill that proposed it be put under the judiciary, the Adult Client Services Division. I don't know if that's permissible. I can't answer that. They would have to answer that for you, Senator.
There's a House bill moving, though.
There is, and it's being heard again tomorrow in the second committee, Public Safety.
Oh, okay.
It's in a draft form already, in HD1.
So you said corrections said that it's not for them to do.
They don't have jurisdiction, Senator, because the person is no longer in custody.
But if it's false imprisonment, they're still in custody, they would.
But they would have to be released from custody immediately
to be
once
able
they're
to
case is dismissed. So they lose jurisdiction over the individual. I believe that was the point of their testimony. I can't speak for them, I'm just reciting what they testified to at our hearing last week before the House Committee.
So I guess your whole point is that you think the current process works fine. Is that my understanding of what you've been saying?
Yes.
So I'm just curious, if it's working fine, why are all these people coming out testifying, saying that reform or some type of changes are needed? Because I think I think there's work in the bill, obviously, that needs to be done. But I think it should be done a little more surgically, probably. But I think if the AG is not necessarily being proactive, I just want to understand why not, especially if there's people that are saying that we need reform, right?
Right. I understand the issue being raised. The process may have been moving slowly. Mind you, I'm aware of only 4 petitions having been filed under 661B. So when we're talking about...
But is it because it was too restrictive, or...?
I don't know. I can't answer the why. That would be speculative for me to say why only so many petitions have been filed.
But it seems like the practitioners are coming out and saying it's convoluted, right? The people who actually have to work with people to bring the petition to you.
You do. You would have to file the petition.
And they're saying it's convoluted, right? So that's why it's concerning to me.
I think all lawsuits are, contentious, but there still has to be that litigation process where there's actual merits and a decision is made on the merits, not an automated system.
No, I get it. It's just if the AG is taking the position that it's fine and we're not going to move and we're not going to try and suggest solutions, that's concerning too. So I would hope you would go back and assess what's been said and being like, okay, if there are changes, maybe the AG really needs to lead what the changes are going to be versus saying, oh, no, it's fine, but obviously, we're having this bill because it's not fine, right?
I understand your comments, Senator, and I think we have had discussions about our better understanding based on the outcome in Jardine and the Supreme Court's decision in helping define what actual innocence means under 661B in grounds consistent with innocence. I think it has moved the needle a bit in evaluating what these cases mean in terms of discussions and resolutions. I can tell you in a case in particular that when settlement discussions commenced in December, a settlement was reached weeks later. So once the settlement was extended by the petitioner, a settlement was actually entered into weeks later. So I cannot say that there is something lagging in the system. I honestly don't know because I'm the prosecutor. I don't do the civil side of these cases. I'm just a firm believer in cases being decided on the merits, not an automated system.
Okay, well, maybe you need to take this back to the AG, right, to kind of figure out where we're going to head with this. Because if not, the legislature is just going to keep moving a bill, right?
But the House already has.
Yeah.
It sounds like they've already picked a direction, so to his point.
I understand that, sir, but we have an obligation to taxpayer dollars, so we're going to always fight for cases to be advocated on the merits rather than an automated system.
Oh, that's good, too.
All right, thank you, Chair. Anybody else? Any other questions? You? We're all good? Okay, what we're going to do with this measure is as we do with everything the committee hears, is we're going to defer time certain. So we will be hearing and having decision-making on this bill Thursday, February 19, 2026, here in room 225 at 3 p.m. This concludes today's hearing on government operations. We are adjourned.